Thank you. We're going to get started again. Our next speaker is the Federal Public Defender for the Middle District of Tennessee and has been since 1985. And don't start getting ready to apply for his job because I don't think he's going anywhere. He was born and raised in Nashville. And I don't remember where you went to college.
I don't either anymore.
But anyway, Mr. Henry Martin.
Thank you. When I'm the one that's got the resume of about 3 lines with no name in the handout. When Doris first asked me to do this, my initial response was, of course, yes, because no person in their right mind says no to Doris Holt. But then as I thought more about it and I read the assignment that she gave me, I began to regret having said yes and trying to figure out what in the world I would say, either to fill up a half an hour or to keep it down to a half an hour. And then about several years ago, I was asked to give a similar talk to capital defense litigators, the survivors of the old death penalty resource centers who had been absorbed into the federal defender program. And I, as a longtime federal defender, was asked to talk to them about the history of the federal defender program to make them feel warm and welcome in our community. And as I was giving the talk, which I thought it was kind of a strange way to make them feel welcome, is by talking about the history of the Criminal Justice Act program. And sure enough, as I was benumbing their sensitive souls, from behind me, the host defender, who was still feeling chafed about some perceived slight at an earlier defender conference, says loud enough for everybody in the room to hear, "Henry, you're killing them, you're killing them." And sure enough, the laughter across the room woke up about half the room. So I'm going to try to not kill you today, and I know my good friend Doris will not say anything, even if she thinks I am killing you. So my first problem in deciding what to say to you was addressed by just grabbing up the rules of professional conduct, reading cases, going to the ABA that's done a tremendous amount of work on the responsibilities of lawyers and of public defender individuals and systems. And then I got to thinking, well, the topic is to talk about the federal defender program and the ethical role of a defender office. If there's anything I know about, I ought to know about that. I mean, I ought to be an expert on the subject, as long as you don't apply the Daubert standard to it. You know, for the last 29 years, I've been representing drug dealers and gun runners and wackos and lunatics, and the best of the class, of course, are the bank robbers, the real convicts, and then the worst of the class are the former corporate CEOs. And so if I can represent all those kinds of people for all these years and not be disbarred, I ought to know a little something about the ethical practice as a public defender. So what I want to try to do, and I am going to try to keep it to a half an hour without too much war story kind of stuff, is, okay, well, you might say so. I don't know if they're going to agree. Is to talk about the development of the program, and I've kind of divided it into two eras. Based on the context in which the program has found itself, and then shift gears and talk something about the ethical implications of individuals and institutions in indigent defense. The two eras that I want to talk about are first the 60s and 70s, which I can see from this audience many of you lived through and many of you were not even around. So. I'll sort of hit on some of the highlights and then shift to the more recent period. But there were a number of things that happened during the 60s, including Gideon and the Criminal Justice Act, and some other things going on in the society at large that I think acted to transform the practice of criminal defense, be it indigent defense or otherwise, from sort of the fringe areas of the law, from the field of the thespians and the extroverts to a field that now I think may be the most specialized area of the law requiring the most diverse and unique sets of skills in the practice of law, more so than any other area of the law. And the factors that I think combined to cause that transformation, obviously, for today's topic, first and foremost was Gideon v. Wainwright and the Criminal Justice Act and the Allen Committee that Art talked about. Because what that did was finally change for the public and for the bar the responsibility for providing representation from the pockets and hearts of lawyers to the place where it belongs, and that is the pocketbooks of the government. It's the government's responsibility. And the Criminal Justice Act was really the first comprehensive effort to address that responsibility in a meaningful way. Prior to that, as Art said, and as I experienced when I was a young lawyer, if you had any interest in criminal defense or really in the practice of law in general, what your mentors would tell you is, young man, go down to the courthouse, go down to the criminal court when they call the docket, see if you can't pick up a few appointments. You might get a few dollars depending on when this happened and where this happened. More importantly, you can get some cases. You can learn how to try a case. You know, you can learn how to practice law. I mean, nobody really thought too much about the fact that the person you were practicing on might not want to be practiced on. I mean, we don't teach surgery by sending somebody down and say, just go, you know, cut on a few people until you kind of figure out what's inside them and, you know, and how to make it better for them. But that's how most litigators, when I started practicing, learned how to litigate. Law schools surely didn't do anything to teach you how to litigate. And so in the 60s, that finally began to change. And it began to be the case that you could get paid, and so that people who were not inexperienced, unskilled, had an incentive to go get appointed and handle a criminal case, and had the incentive then to apply the skills they had developed to this individual, in addition to the individuals that they were representing for fees or retainers or contingencies. In addition to that, during that time, there was the criminal law revolution. They actually wrote books on that during the time. And that's basically the Warren Court and the discovery of the Bill of Rights by judges and defense lawyers and reluctantly prosecutors across the country. There was an old, long-time prosecutor in Montgomery County who told a former partner of mine who was then a deputy AG, said the Warren Court was the best thing that ever happened to criminal law. Said the discovery of the Fourth and Fifth and Sixth Amendments, the ability to file motions, to get evidence suppressed, said it changed the practice of criminal law from who could go out and hire the best witnesses, because it gave the defense something to fight with. It gave them a weapon. They had the Constitution. They had the process that they could litigate on behalf of their clients. So it worked to improve the quality of practice, and once one person filed a motion to suppress and succeeded, then that set the example for others to do it. And of course, over the years, as those motions were filed and had some success, two things happened. Quality of law enforcement improved. Quality of the treatment of individuals accused of crime improves. Their access to rights to which they were entitled increased. Of course, also the courts decided maybe we've gone far enough, and so Fourth, Fifth, and Sixth Amendments are more historic factors now than anything else. But it did improve. It professionalized the practice of law. At the same time, also, there was the social activism of the 60s. There was a whole generation of people who were bright, were motivated, and wanted to do something to make a difference in the world, wanted to improve the plight of their fellow men and women. Many of these people came into prosecutors' offices, came into defense offices, came into the practice of law for a variety of reasons, to do a variety of forms of public service. And over the years, many of those people have become judges. And so that, too, has served to improve the quality of practice. Now, all of that, though, had relatively little initial impact on the federal courts. At the time of Gideon and the Criminal Justice Act, and up through the time, actually, that I became a lawyer and then finally became a public defender, federal courts had limited jurisdiction. They had, when I started at the office, we did embezzlement cases, we did counterfeiting cases. If we got lucky, we might get a bank robber every now and then, or every now and then some wacko who stole dynamite from the construction site and thought he'd have some fun with it. But most of our clients were released on bond. We didn't do initial appearances because the magistrate judge would appoint us, issue the bond, give them the charging papers. Sometimes the U.S. attorney would give them a copy of the file so the discovery was already done. They'd come to our office and talk to us, and we'd represent them. You know, we'd either try a little case or we'd enter a guilty plea. They'd be sentenced. They'd be put on probation. It was a real nice life. We generally, in Nashville at least, we would catch up to our 75%, which is we were supposed to keep 75% of the appointed cases, you know, by early August. So we'd stop taking appointments. I mean, it was like the old days of terms of court. We'd, you know, from August and through September, we could catch up on work. Well, those days have changed. The other thing you would have seen, if you had walked into a federal defender office here or in Nashville in the late 70s, you might have thought you were in the Veterans Administration. I mean, there were metal desks, there were these plain, bare walls. There'd be somebody who'd know how many paper clips were in the filing cabinet and how many Bic pens were in there, how many of those long legal pads were in there, half of which would have the top torn off where they'd been used in a case and then recycled for use in the next case. And we were cheap. You know, we didn't do much and we didn't charge much. We didn't cost much. Well, all of that I've just described began to change in the 80s, and that's because the world around us changed. A lot of things began to happen, some of which seemed kind of innocuous at the time. The Bail Reform Act. I mean, it sounds like a wonderful thing. And that's the single thing most responsible for the statistics that Art quoted about the difference, you know, 40 years ago in the number of people released pre-trial and the number of people released today is the Bail Reform Act. It made possible pre-trial detention on suspicion of danger. And so now the vast majority of our clients are locked up. So they don't come to see us. We go to see them. And it's not, you know, across the street. It's not across town. For us, it's Springfield, Tennessee. It's Bowling Green, Kentucky. It's Litchfield, Kentucky. There are a few down here in Mason from time to time. And so, it's changing. The Sentencing Reform Act also sounds like a good thing. I mean, Senator Kennedy was one of the sponsors of the bill. We're paying a heavy price for that still today. That, of course, brought in the guidelines a few years later. And then coinciding both with the Bail Reform Act and the Sentencing Reform Act is the growth of the Bureau of Prisons. When I started practicing, there were about 30,000 people in the Bureau of Prisons. Staff of the Bureau of Prisons is about 40,000 right now. Population is, you know, it's including in the private industry, it's close to 200,000 people locked up on federal issues. And then, of course, the decision by those who can make the decision is to turn the federal courthouses into state court west. I mean, the introduction into federal court of a concept of broad and general jurisdiction rather than limited and special jurisdiction. So the U.S. attorneys found they could, you know, fill up their statistics and fill up their staff by bringing gun cases and drug cases, street crime cases. Everybody got happy because you could double or triple the amount of time somebody could get. They discovered the magic of criminal records, that lo and behold, even if what the person's doing now is relatively innocuous and harmless, you can bang them down with 10 years, 15 years, 20 years because they've got a criminal record. And all of a sudden, the federal courts were swamped with cases. At about the same time that all those things happened, but with less notice, the death penalty came to the federal jurisdiction. Initially, it was with the passage of a death penalty bill of a fairly narrow scope. Wasn't even sought for a number of years after that, and then one time in Alabama on a drug case. Several years passed before the next case was filed. But then the act was expanded. Resources were devoted to it by the government. It again became a good tool to take people off the streets, to fight crime, fight drugs. And it grew in the number of people that were charged with and prosecuted for capital eligible offenses. And at about that same time, the federal courts had recognized that nobody really was taking care of business for people already sentenced to death. Most states did not have a right to counsel. Federal judges were getting habeas petitions on scratch paper, on toilet paper, and then having to sort out the facts and the issues in a case. And so the federal judicial system, as sort of a preventive measure and a restorative measure, addressed the issue, and the concept of resource centers, death penalty resource centers, was created within the confines of judicial conference committees. And that led to the creation, and I think ultimately in 13 states, of resource centers that were primarily funded by the federal government, but also funded in part in most states by state or private or charitable funds. Tennessee had one. Most of the states in the South and on the West Coast and a few in the Northeast did. They became unpopular and unsustainable politically, and they were closed down. And the Federal Defender Program absorbed, as I mentioned a little bit earlier, the federal component. I mean, the resource centers did everything from pretrial through habeas corpus. The federal defenders absorbed much of what the resource centers had done in federal court on habeas corpus. That's grown now so that we have, I've forgotten, maybe 16 or 17 capital habeas units spread out across the country that do nothing but represent people who have already been sentenced to death in their habeas litigation, now some in clemency, and now occasionally even with being able to go back into state court, either directly or with the assistance of private or state agents. But that also has brought a huge challenge to the Defender program. And the program, luckily, had those 60s and 70s years as sort of an incubation period to begin to build itself, to prepare itself unknowingly for the onslaught of challenges and burdens that was to come beginning in the 80s and continuing on through into this century. And the foundation proved to be exceedingly strong. And the components of that system, I think I've reduced to about 5. Number one is salary parity. The Criminal Justice Act has long provided that the assistant federal public defenders or federal community defenders may be paid the same salary as a similarly experienced assistant United States attorney. That was different than the practice in state courts and what systems had existed in the past. Those funded by charities and foundations paid nominal wages. But all of a sudden, we could pay the same salary as an assistant United States attorney would get, and that allowed us to attract people who were motivated to come anyway but couldn't have for financial reasons, and to retain people of talent and skill over the years. Now, I'll have to say that the heads of the office didn't get parity initially. We were not considered to be the same as a United States attorney. We've ultimately, finally, over the years, have worked our way up, I think, in part because Congress has kept them with a ceiling on their salary, so we finally sort of caught up to them. But the ability to hire lawyers at the same salary with the same benefits that the government did has allowed us to compete with them and to build a staff nationwide of incredible people. That's how young Doris Holt got her start coming out of Chambers and working as an assistant federal defender. Secondly, each local office was budgeted to not only staff in a comprehensive way. We hired not only just lawyers and now legal assistants, used to be secretaries and receptionists. We hire investigators. We now hire paralegals. Some offices will have interpreters, social workers. We have budgeted funds to contract with any form of assistance that we need. If we need accountants, if we need firearms experts, if we need chemists, whatever our needs happen to be, we have budgeted funds that we can use to augment and complement our representational services. We have, and we don't go to the court for that. If somebody that handles the case in my office says, I have got to have a psychological exam given to my client, they have to convince me. I mean, I know what limited funds are available in the budget. I've been practicing long enough to know whether or not it's going to be useful in this case with this client, or if it's just to satisfy the client, and whether or not this would be money well spent and how much money it really ought to take. But we don't have to expose the essence of our case to anybody outside the office in order to have access to the funds and the resources that we need. And in the past, up until last year, if I didn't have enough money in my budget and I could demonstrate that it was a legitimate need, then I could go to Washington and get supplemental funds. Or if I had a big case come in that I had not anticipated that had needs that I could not meet with my annual budget, I could go back to Washington and could get additional funds. That prospect in the future is a little less sure than it has been for the past, but it's been one of the real strengths. And I'll have to say, too, that one of the foundations, of strength of the program has been the quality of judges and prosecutors in federal court. And I hope nobody here is a state judge or had a history of being a state judge for a long time, because I really don't intend to denigrate state judges or state prosecutors. But federal judges and federal prosecutors, Art's looking around like I'm likely to offend somebody. State judges and state prosecutors run for office, and they work in a system that is never funded as well as the federal system. They don't have the resources that their counterparts in the federal system do, and I think that has a direct bearing on the quality of justice rendered by prosecutors and by judges. There are greater resources. It's a better job. It attracts people that can feel free once they get there generally to do what they think is right, not what the elective constituency will expect of them or demand of them every 4 or 8 years or however often. And so I've had the privilege over the course of my practice, particularly as a federal public defender, to practice before federal judges, every one of whom was dedicated to the concept that my clients deserve fair treatment, particularly when it came to the lawyer involved. Now, when it came to sentencing time, their concept of fair oftentimes was different than mine. But in terms of the process of getting there, I have never been questioned by a federal judge about whether or not I have gone too far, whether or not I'm wasting time or money on behalf of the client, nor have any of the people in my office. I've dealt with prosecutors who were by and large fair and reasonable, and that has made it easier for the Federal Defender Program to develop the strength and expertise that it has. Two final things that are a part of that foundation. One is the relative independence that I have as a federal public defender, that Doris has as a federal public defender, and our counterparts do around the country. We really don't have bosses on a day-to-day basis. There's nobody looking over my shoulder passing judgment on what I do on my cases or with the staff in the office. I'm appointed for a 4-year term by the Court of Appeals. I have to be reappointed every 4 years by the court. It has a study conducted by a local committee of practitioners that consults judges, prosecutors, and probation officers and others in the public before it reappoints me every 4 years. So I have some responsibility. I have somebody checking my homework on a periodic basis, but not on a day-to-day basis. I make decisions about how to spend the money that's given me. I get it from the administrative office, and more so in the past than in the future. They don't scrutinize how I spend it. I'm a government employee, so there are legal restrictions on how I spend it, but I can spend the money in which case I think needs it and how I think needs it. And that independence has I think, led to the strength in the program. And we're independent also from politics. I don't ever have to tell anybody what my political persuasion is. Some guess on some of it, but I'm not, in my office, I'm not a Republican or a Democrat. My judges are not Republicans or Democrats. The people in Washington in the administrative office are not Republicans or Democrats, at least in their jobs. And that also, I think, allows us to focus on what we need to focus on. That's the law and the needs of our clients. So, yes, ma'am. Oh, yes, ma'am, there was. Yeah, I'll say just briefly, last year, almost everything that I've said about the program and will say about it was shaken to the core. About this time last year, which is, we're on a fiscal year that starts October 1, so we were halfway through our fiscal year when we learned that our budget was going to be half what we thought it was going to be. And so we had to absorb over the remaining half of the year a significant cut in funding that really devastated the program. We laid off, I've forgotten, hundreds of people across the country were laid off. Offices that didn't lay off furloughed. We were closed every Friday for 17 weeks. I know Darcy's office lost several people and had some furloughs. For a sports analogy, I mean, we were knocked to the canvas. And we didn't lose consciousness, but we were lying there blinking with the insects buzzing around in our vision for a while, and we're sort of back up on wobbly knees now, but we're not being given a lot of guarantees that make us feel good about the future. And I think partly because of the strengths that I've described, we survived that, and we frankly have applied some of the skill sets that we learned as advocates for our clients to be advocates for our program. For instance, we learned that we had a fairly almost friendly reception in Congress. As long as I've been a federal defender, we've been afraid of Congress. We've said, do whatever we need to do not to have Congress know we exist. And we had a big fight about 20 years ago on the Prado Committee, the reform, with some people saying we should be fully independent with a little defender general somewhere. And the majority of the defenders said, no, we don't want that. So we've seen legal services, how it survives independent. We found this year, last year, that if we didn't speak up, we weren't going to be spoken up for. And we went to Congress and we found favorable receptions. People recognized the Defender program as well run, as necessary, and were given assurances that it would be funded. We're facing a different challenge now. It's like in, was it Rocky II, when that big mammoth Russian is the one, you know, this big mammoth Russian for us now is something called a work measurement study that the Judicial Conference and some of its committees have decided to take a look at how we are structured and staffed and resourced. And so we're now applying our skills as advocates to that process. And we probably are spending anywhere from 10 to 30% of our time across the country defending ourselves in that context, you know, rather than focusing on our clients. But we feel we need to do it. Well, in the 80s, with these strengths in place and these challenges, what are the results? I think pretty good. Our clients don't necessarily think so. I mean, we have clients, you know, serving decades and decades of time. I mean, young people, middle-aged people, old people. And it's hard to say that we're good lawyers when our clients go off for 15 to 25 years and more for things where we don't see the harm that justifies that length of a sentence. But I guess maybe to make ourselves feel like it's worth doing and that we are not as bad as it looks by looking at the numbers, there have been some measures of the quality of representation in federal court. There have been a number of studies conducted by the Federal Judicial Center and some outside organizations, and they routinely have found, in terms of familiarity with and expertise with criminal law, and particularly with the sentencing guidelines, almost every one of them has found federal public defenders #1 in terms of quality of expertise. And below that then come, I think, U.S. attorneys and panel lawyers. And then you trickle on down below that, and at the bottom, frankly, are private attorneys who are neither panel lawyers nor full-time public defenders. So that gives us some reason to believe. And also, I don't know here, but I suspect it'd be the same as you'd find in Nashville. Every district judge in Nashville will tell anybody who asks, and some that don't, that the best representation in their courts is provided by the Public Defender's Office and by the panel lawyers. Whether it's civil or criminal, any context, they had rather have a case before them handled by a public defender or a panel lawyer than by any other kind of lawyer. It's going to be handled more professionally, more responsibly, and with a better chance in a reasonable time, in a reasonable way, getting to a reasonable and appropriate result. And I think that says something about the quality of the program. I think the same thing is true in the courts of appeal. Now I'm going to, how much longer do you want me to talk? Because I ain't even talked about ethics yet. Well, she didn't give me any water to drink. There's no way I can talk for 30 minutes, so you don't have to, you hadn't seen me drive people out of a room. They'll leave when they get ready. Let me shift and talk just a little bit about the ethical part of my presentation. And I'm going to talk both about the ethical responsibilities of individuals in an indigent defense system and of institutions. And I'll start with the individuals on the line, the line assistant federal public defenders. And the answer for that is real easy. The ethical responsibilities are absolutely the same as they are for those of you who are in private practice. And those responsibilities are found primarily in the Code of Professional Responsibility enacted by the Tennessee Supreme Court. And in some it says, and I could substitute, when I read lawyer, I could easily substitute public defender. It says a lawyer is an expert in law pursuing a learned art in service to clients and in the spirit of public service, and engaging in these pursuits as part of a common calling to promote justice and public good. So whatever the responsibilities are for a private attorney, they are the same in terms of responsibilities to the client, responsibilities to the court, responsibilities to adverse counsel, responsibilities to the public. When you step from away from the line just a minute up to the supervisory level, and the Federal Defender Program is small enough that there's only a small cadre of people who are supervisors but not heads of office, so I'm going to lump in supervisors with managers. And those responsibilities there are twofold. One, in terms of the practice of law, the service that's rendered by the office. The responsibilities of a supervisor are, as I said for the line assistant, the same as a supervisor in a private law office. If I, as the head of my office, am aware that somebody on my staff is conducting themselves in a way that's in violation of the Code of Professional Responsibility, and knowing that, I either condone it or tolerate it, don't change it, I'm ethically responsible for that. I can be held to the bar for disciplinary action if I allow anybody that works in my office to engage in unprofessional, unethical conduct. That's the same for a partner in a law firm. And so those, again, responsibilities are no different. Where you begin to see some differences are in an institutional framework, or the portion of my work that is more of a bureaucratic or administrative component, and that is as a provider of defense services, of indigent defense services. And in that area, except to the extent that it involves the actual practice of law, it's really not covered by a state's code of professional conduct. The American Bar Association has devoted some time and some energy to trying to identify what the responsibilities are of those who provide indigent defense services. And I've listed those in the little handout portion that I sent in. They primarily are shepherded through the process and maintained by a component of the ABA called Standing Committee for Legal Aid and Indigent Defense, or the acronym is SCLAID. And if you are interested in further reading, you can go to that section of the American Bar's website and find a plethora of studies, of standards, and other forms of guidance. But in one thing in particular, there's something like 10 guidelines for providing adequate resources in an indigent defense system. And it tries to measure it by how you know when you're not doing enough. And that is when you begin to get complaints from the field that we can't do this, or this because we don't have the time, we don't have the staff. And the kinds of things that they are looking at are, sufficient time devoted to interviewing and counseling, prompt interviews, necessary investigations, sufficient legal research, sufficient preparations for hearings, sufficient preparations for trials and sentencing processes. And so those are the kinds of things that are my responsibility to the extent that I'm responsible for providing resources to my office. Now, responsibility on that is twofold. One is it's up to me to tell the administrative office what I need, what my office needs. In spite of my years of staying away from numbers and calculations and stuff, I've got to know enough about accounting to know and budgeting to know what my office is spending, what it needs to be spending, so that I can inform the administrative office and I can get, to the extent they can give it to me, adequate funds. My other responsibility is stewardship. I've got to take care of what they do give me. I've got to be careful in how I spend it. I've got to spend it in accordance with the law, and I've got to exercise good judgment because I know I'm not going to have enough to do everything I would like to do for every case that we have. So I've got stewardship and I've got reporting responsibilities. At higher pay grade levels, the administrative of the Office of the United States Courts, the Judicial Conference of the United States and its various committees, and the Congress of the United States all have the responsibility to meet these guidelines that the ABA has set out in terms of making sure that there are adequate resources in the office, in the field, on the line, so that the lawyer can do what the Code of Professional Responsibility requires him to do and what his own moral sense and good conscience and good judgment dictate to him or her that are necessary for the client. And those, frankly, both by inadvertence and neglect and by goodwill, good faith, and good judgment, those other providers have carried their load appropriately in the time that I've been a federal public defender, and I'm hoping, in spite of a little blip on the screen last year and this year and probably next year, that will continue into the future. And if not, there may be a vacancy in the Middle District of Tennessee. Now, I'm moving relatively close to the end of my notes, but let me talk a little bit about what that means to me. Again, I think I'm an expert in the ethical practice in the federal defender offices. While I would, in my dreams, there's probably a little bit of James Dean or somebody, or if I were a little bit younger, maybe Chris Rock or somebody that, that's going to just disrupt everything, that cause chaos, and that's how you protect your clients. That's how you slow down the system. You throw a wrench in the gears. You throw the grenade, out of the trench, and you wreak havoc, and you break things down and keep things from happening to your client. And while I don't deny that mindset is always there, that it is part of the brainstorming of the creative process, I'll have to say that in my years, both as a panel lawyer in private practice and as a public defender, I found that really not to be the best way to practice law on behalf of my clients. I have found that a hostile relationship with the judges before whom I practice is not conducive to the interests and protection of the rights of my client. And that's, again, is partly a reflection of the fact that, they're good, decent people trying hard to do the right thing. But I found it's not necessary for me to challenge their morals, their value judgments, or their character in order to challenge their thinking, the conclusions or opinions that they've come to, if I need to do that on behalf of my client. In fact, I've got a better chance of persuading them that their initial conclusion about this case, or their thinking about this kind of offense, or this kind of response to that kind of offense is wrong if they know and respect me, and they're not going to do that if I don't show them that I know and respect them and who they are and what they're doing. So contrary to the image in my fantasies and that of others, an appropriate, professional, respectful relationship with the judiciary works and works better than the adverse. And the same is true in the relationship with the U.S. Attorney's Office. Now, there may be times when I personally do question their character, their value system, their morals. I generally try to keep that to myself. And by and large, those for whom I do have those questions are in a distinct minority. Many of the people that have populated the United States Attorney's Office in the Middle District of Tennessee have been and still are my good friends, people whose judgment and values I respect and trust. But I am compelled by what I know to be the right thing to do to treat all of them as fitting into that category, whether they do or not. More importantly, probably, it's important for them to know that me, and more than me, the lawyers in my office, will fight when we have to, when we need to in a case. We'll fight hard, but we'll fight fair within the rules, hopefully using a little more creativity, a little more imagination than they're used to. But it will be a fair fight, at least on our behalf. We're not going to take cheap shots, not going to try dirty tricks. And that they need to know that when we don't have to fight, when we can resolve a case, we will. That we're not going to strut around and file motions just to make them work or go through a hearing if we can settle a case appropriately without doing that. And if we can save resources, because they're actually scrapped for resources now, just like we are. If we can save resources and still come to an appropriate resolution, then I think that too is a better way to address the client's needs and concerns than just being constantly combative. Now, there are two components in the relationship with the ethical relationship with the judiciary. One is, I think it's important for the way that I conduct myself and the way that the staff of my office conducts itself in such a way so that the judges before whom we practice know that it will be possible to reach a reasonable and practical resolution of the vast majority, if not all, of the problems that we mutually address. And that I'm not going to unnecessarily interfere with how they conduct their business, how they process cases. I continue to learn just how complex and overwhelming the burden is on United States district judges. I mean, for years, all I have seen is just one little slice of the pie in criminal cases. And then in more so in recent years, as I've had more and more administrative conversations with the chief judges primarily, and I get a peek inside their life outside of criminal law. I don't know why you guys took those jobs or how you do them. I mean, I don't know how they keep up. And when I used to think that if I don't file something until right before the hearing, that'll give me a strategic advantage. Well, it's going to mean the judge won't have a chance to read it. So, to the extent that I in my office can let the judges know, we're not going to make your job any harder than we need to, and we can reach, in most cases, a conclusion that we'll all feel was reached fairly and appropriately. We may disagree on what that final conclusion is, but we'll agree that we got there the right way. At the same time, I think it's my responsibility and the responsibility of public defenders and panel lawyers, any criminal defense attorney, to make every judge and every prosecutor a little bit uncomfortable about what they're doing. They need to have a little doubt about the case against the defendant, and they need to always be uncomfortable in deciding what the right punishment is, unless it's probation, and sometimes even then. It's so easy to be numbed by a process like the guidelines, where everything is reduced to factors and numbers and processes, to send somebody away for 25 years and not realize what you're doing and the impact that has on a whole range of people and not just the individual in front of you. And to the extent that during the reign of the guidelines, that we were able, even though oftentimes we were nothing more than a grain of salt or a grain of sand in somebody's shoe, to the extent that we could make prosecutors and judges uncomfortable about that process, make them realize that 240 months is not just a number. That's a long time for somebody to sit in what essentially is a warehouse, away from their family, with no hope of rehabilitation, no hope of treatment, no hope of a life after that. And it's not that they're not aware of that. It's not that they don't know. It's not that they haven't maybe visited jails or prisons to see what life is really like. It's that, again, their workload, just like ours, is so overwhelming that if you can compartmentalize, if you can reduce, if you can focus on things in ways that don't engage your full soul in something, you can get through the day. And it's partly our responsibility to keep that from happening, to keep their soul engaged, their heart engaged, their humanity engaged. And that can be a challenge, because there's going to be a time when all they feel is that grain of salt in the shoe, that pebble under their foot, and not recognize that as advocacy. But over time, if you have built the relationship that I described earlier, then they will accept it, and I think that, and I hope at least, that they appreciate. I know that as hard as it is now, and the fact that they may be a lot harder to sleep, the federal judges I know, at least, feel better about sentencing now, even when they're imposing the same sentence they might have under the full mandatory guidelines, because they know more about the individual, they know more about the alternatives available, and it's a decision that is more fully thought through and more fully considering all of what the real factors are. And then I'll conclude by saying that the two real ethical challenges that I face and have faced my entire almost 29 years as a public defender, and that every good public defender faces, that is similarly faced but not with the same intensity as for panel lawyers, and that is the challenge of avoiding selling out or burning out. In this business, we absorb a tremendous amount of pain. Our clients are in pain, and others in the system oftentimes only see the record and the crime, and we see the childhood, we see the abuse, we see the neglect, we see the lack of job or other opportunities, the failed relationships, the mental illness, the physical illness, and we absorb all of that. We see the victims and what happens to them when they're crimes of violence. We see our clients' families, if they still have one, and what happens to them. And we see each other. And year after year of absorbing pain from others, of dealing with the suffering of others, and trying to do something to mitigate that, particularly when at the end of the result your client goes off for 20 years. The wear and tear on your physical well-being, and more so your mental and emotional well-being, is tremendous. And there are lots of protective mechanisms going on in your psyche that will try to protect you from that. And that is, again, the distancing yourself, the compartmentalization, the reduction of things to take out the emotional component. And some of that you can avoid, some of that you shouldn't avoid, because otherwise you won't survive. But you've got to somehow find that magic line that you're not going to go this far. You're not going to give up your emotional reaction to a situation totally. You may try to cabin it a little bit, you may try to control it, but if you give it up entirely, you might as well walk away. And that's where the burnout comes, where you have totally given up on your emotional reaction to it. At the same time, you've got the tension between being an advocate yet being a respected player. There is combined with, I got to face this prosecutor tomorrow, and if I tell her what I think about her right now, it's going to be a lot harder tomorrow in my next case to face her, so I've got to just bite on that and just not say anything. If I file this motion before this judge and say, Judge, you need to recuse yourself because of X, Y, or Z, and I've got to appear before that judge in every other case, there's some pressure on me not to file that motion. If my office is engaging in a form of litigation, maybe death penalty work, that involves us saying some things, doing some things, filing some things, litigating things that maybe judges as far removed as Cincinnati might not understand why, might see it as nothing more than smokescreen, than delaying action or whatever. I can make myself less attractive for reappointment. So do I moderate the energies of the lawyers in my capital unit to protect myself? I hope I don't. and I like to think I don't. But that pulling in the direction of worrying about your personal interest, your job, and two, keeping yourself emotionally and mentally intact, while yet remaining a vigilant and zealous advocate for the client, is pretty hard to maintain. And the way we do it primarily is our network of relationships within the office and within the community. And so we try to cultivate a relationship, inside our walls that's, supportive, that's sensitive to each other's pains and suffering. I'll guarantee you there are more Buddhists in the Federal Defender Program than there are in the United States Attorney's offices across the country. And we need it substantially more than they do. One last word. Particularly as the budget has become more and more problematic, we hear from time to time things about, well, you're not entitled to a Cadillac defense. And so I guess the alternative is, well, we give them a Chevrolet defense. Well, hell, it's safer to walk the streets of Baghdad today than it is to drive a Chevrolet. So hopefully that's not the alternative that's going to be provided to us. And what I'd like to think that with what we need and what we are entitled to and should have maybe is the Subaru defense. Something that will reliably get us where we need to go today, tomorrow, and for weeks to go, and keep us relatively safe while we're doing it. For an example, let me tell you about a case that we recently had in our office that you'd think it didn't turn out too well when the guy went off for a little over, just over 7 years in prison. He was represented by a man who since retired, had something like 45 years as a lawyer, 22 years in my office. He'd worked both as a state and a federal prosecutor, as a private practitioner, and then again the last 22 years in my office. We also had an investigator on the case who retired with honors from the Secret Service and has been in my office for about 10 years now. And it was a series of bank robberies where the proof was astounding, including some key admissions by the client. Client had, I think he's mid to late 40s, all but a year or two of his adult life. He'd been incarcerated. He'd made good use of that year or two. He'd robbed a number of banks, probably. Had been charged, I think, with either 3 or 4. Did, the standard review, interview the facts, review the discovery, interview the client. Worked out a reasonable understanding of the guidelines. I think there were no gun charges brought. Guideline range of 151 to 188 months. In a follow-up interview, the investigator was sitting down with the client and just kind of making sure they'd covered all the bases. And the client said, let me tell you something I've never talked about before. And lo and behold, the whole world opened up. This guy had family we didn't know he had. He had his childhood was one of those out of a Dickens novel, abuse, neglect, abandonment, violence against him and by him. People spread out across the country. He didn't know whether they were dead or alive. Investigator could have said, clear issues, no issue as to guilt, reasonable sentencing approach, guidelines not terrible, good sentencing judge. We got a lot of other things to do. We don't need to pursue this. Instead, he started making phone calls, started doing internet searches. He started finding people around the country, this client's, what was left of his family, and started putting them back in touch together. The end result was there was some reconciliation, may not last. There was significant understanding for the client who he is, where he came from, how he got there, what his world really is. He apparently gave an allocution, which I didn't know was coming. I wasn't there. I've heard about it since then. That was moving and was significant, and it resulted in the judge on her own reducing the sentence down to 80 months or something in that neighborhood. Now that's not a not guilty. That's not he didn't walk out of the courtroom. He may reoffend. We don't know. We don't know if this experience has been transformative for him. But we took about 6 years that he would have spent in a warehouse somewhere and gave it back to him. And we did that with the judge, with the prosecutor participating, but we did it because we gave him the defense that he was entitled to. We followed up on the leads that were there that may not have gone anywhere, but we followed up to make sure, and they made a difference. And if anybody's going to tell me that 6 years in somebody's life, the freedom for 6 years, is not worth the extra dollars and the extra time that it would take to do that, and if that's a Cadillac defense to which they're not entitled, then that's somebody whose value system I do challenge. Because that's what I've got an obligation to give to my clients, and that's what the people in my office and the people of in Doris's office try every day, and the people like Art and the other panel members here and across the country try every day to give to their clients. And let's just hope that Congress and the Judicial Conference agree with that and continue to do what they can to provide those resources to us and give us that Subaru to drive back and forth. I'm dry and I'm out of things to say.
Well, don't go anywhere. I want them to ask you some questions if they have any questions.
Okay, let me drink some water then.
Do you all have any questions about the ethical implications for attorneys practicing indigent defense? Yes, Don.
I know that the criminal justice section in the American Bar Association have been working on new standards or revised standards for defender functions and prosecutorial functions that they hope to present to the House of Delegates, I think either in August or in February. Are you familiar with that project at all? And is there anything about those new standards that you have a particular concern about?
I'm aware of what you just described going on. Now, in times past, we would have been involved in that. And I'll have to admit that this year we were not. For unrelated reasons, we're not as active in the ABA and the criminal justice section as we used to be. For a long time, a man named Terry McCarthy, who was the defendant in Chicago, was sort of the heart and soul of the criminal justice section, and we had substantially more involvement and input there than we would have given our size otherwise. Since his retirement, and as we have had the last year or so to sort of refocus all of our spare energies to survival of the program, we just have not. Our representative in the council is not as active now as Terry used to be, and most of our individuals have not had the time to engage in that process, although we should, and in the past we would have, and I hope in the future we will again. We do anticipate working with the with ABA on a more narrow focus, and that is to get their assistance as we're going through this reevaluation of what our workloads should be and what our standard of practice should be, and we're hopeful that the ABA will continue to take a strong stand on that. You can have anything you want. It's been a long time coming. We don't have much going on in the Middle District, so I don't have much direct experience in that. I'm familiar with the concept and some of the initiatives, and I think it's been long overdue. I mean, we can't continue to lock people up and then just open the door and expect wonderful things to happen. And so the more resources that are devoted to the reentry programs, to job training and placement, to housing, to reorienting people to the world outside, the better. But I don't have any direct. I'd love to have more experience with it. And I'm really encouraged what the Justice Department is doing, not only on that, but also in recognizing the drastic sentences, the overcrowding in the prisons, and trying to do something to change it. Yeah, we were all, well, I think at first we had been disappointed at how little the current president had used the clemency power, and then really pleased a few months ago when he granted clemency, I think, to 8 people, by and large people whose sentences he thought were too long, and now has announced with the Attorney General and the intent to do more of that. And so actually the Defender program, and there's some outside agencies that are getting active in that with, with foundation money and things like that. But also at our next training program in May, we're going to be working on developing clemency approaches and processes to identify people who are now in prison who would benefit from being looked at for the consideration of clemency. And so hopefully, in addition to what's happening with reducing sentences that are now being imposed, we're hopeful that we could actually pull people out of prison whose sentences were too long to begin with.
Ways to see if they can accelerate that process and see if they can use law school students perhaps to help with screening clinical programs, and then reaching out to a number of other entities to sort of band together and see how they can really get this in place and get it expedited and accelerated.
It's springtime in criminal justice.
One more question. I know sometimes it shuts the courts down when defender offices send their staff off to training. But isn't that one of the ethical implications for indigent defense attorneys, that they have to be adequately trained, and that they need to go and network with other attorneys in other areas too, so they can brainstorm and see what they're doing and maybe bring some of that back to your district and try and share it with your CJA panels as part of our duties.
Absolutely. I mean, the training, well, you kind of answered your own question. I'm just your puppet up here, which I don't mind being. But the strong training program that we've had for many years made the transition into guidelines, made surviving guidelines possible. I think if we had not had the training that we had, the guidelines process might have shut down the court system. It certainly would have increased the workload that they did experience from that, would have increased it geometrically. And related to that, as Doris mentioned, is the networking. And the end result of that is, I could fire up my computer now and type in a question about a legal issue, about a particular FBI agent, about a factual issue, an expert or something, send it to one place, a listserv, and well before I leave town, I'd be getting answers about it. And it might be an answer from a panel lawyer in Coeur d'Alene, Idaho, or it might be from a public defender in Manhattan. And it might be, do your own research, plughead. Or it might be, I had a case just like that last week, and let me tell you what I tried. Or I worked with so-and-so, you ought to call so-and-so. And I'll guarantee you that one little transmission might wind up saving $10,000 of time that I would spend or somebody else would spend ferreting through the wilderness of possibilities of an answer to that question. And that happens, every day there are hundreds, if not more, emails like that going around the country through defender offices and then out to panel lawyers that is increasing our ability to defend and to resource a case in a huge way at almost no cost. You got a vacancy? You got any vacancies? How do you get on the listserv? Okay, well, we have the one email that I would send would be to an internal defender program list that would go to one person in every federal defender office in the country. And then in districts, in many districts around the country, there's a panel listserv created either by the defender office or by somebody with the panel that, again, is like one forwarding of that message to the panel listserv. Now, that's not in existence in every district uniformly, but it's growing. And so there may be some districts, I don't know whether y'all have a panel listserv or not. If you don't, you ought to have one. And we were at a meeting in Nashville with the panel talking about all the things we wished we had and we're going to do sometime. And we mentioned something like, a better website or a listserv or something. And I'm up there yabbering away about something, and a guy raises his hand and said the address is, he had gone on his smartphone to Yahoo or Google or somebody and created a listserv. And that now is one of the best resources we have in Nashville. That you can, and it's limited just to the panel and to the Defender Office. And you can ask. We try not to ask stupid stuff that's going to embarrass you if somebody forwards it to the wrong person. But you can ask about such a prosecutor, such a case, what's going on here, and get an informed answer. And we find we're sending queries out because we'll have panel lawyers who have focused more on an issue than we have recently. And we're learning from panel lawyers, they're learning from us, and it's all just by a few keystrokes and sending it out to this listserv. And so if y'all...
The reason I asked that is because the Tennessee Association of Justice has several listservs, and Dean Lorenzi and I are on one, and it's valuable.
Mm-hmm.
It would be great if we could get on panel listserv with the public defender's office, because there's a lot of us out there, and we can share a lot of information.
The danger is, and I've heard that the TACDL, the Criminal Defense Lawyers listserv, almost is unwieldy, it's become unwieldy and unusable because it's just gotten so big and so many people sending so many things that you wind up skipping over it, not having time to open it. So there's a risk that you get too many people asking too many things that it breaks down. And there's also some advantage to having a fairly limited listserv because you can be a little more candid. You don't have to worry too much about a prosecutor reading what you're saying or somebody that really doesn't need to know the information. And again, just the number of emails is reduced if there are only 50 or 60 people as opposed to 500 people on it. So if you do create something, I'd caution you about making it too open to too many people because it just becomes too unwieldy. That's not time saving.